second. Before we do that, just for the members of the audience that are here in the courtroom, everybody here has been perfect in terms of their decorum. But I just want to remind everybody, please have no outbursts of any, and this is difficult to ask, regardless of which side you're on, but no outbursts of any type of emotional outburst or expression, whether you're for the jury's verdict or against the jury's verdict. And that's for a very important reason. Courtroom decorum requires that we respect a jury's work, regardless of what their decision is. And so if you feel as though you can't control your emotions, whichever way they decide, I'd ask you just wait in the hallway, and then you can find out the information of what happens at that point. But if you're going to remain in the courtroom, just please don't show any expression. That way the jury doesn't feel that they're being influenced in any way or criticized in any way, because again, the rules of courtroom decorum require that. All right, so everybody understand that? Very well. We can bring in the jury.
Okay, guys, so they're just bringing in the jury, so they should be seated pretty soon, and we will hear what the verdict is.
All right, please be seated. Ladies and gentlemen of the jury, it's my understanding you all have reached a verdict. Is that correct? All right, if you'll please hand the verdict form to the bailiff. All right, the verdict form is filled out, signed, and dated. I will provide it to the clerk, and she will publish the verdict.
In the Circuit Court of the 20th Judicial Circuit in Lee County, Florida, criminal action. State of Florida versus Christopher Davis. Case number 24 CF 000083. Verdict. We, the jury, finds as follows as to count one of the charge. Count 1, second-degree murder. The defendant is guilty of second-degree murder. Count 2, tampering with physical evidence. The defendant is guilty of tampering with physical evidence. Count 3, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual target. The defendant is guilty of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. Count 4, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. Publix. The defendant is guilty of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. Count 5. Fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, PNC Bank. The defendant is guilty of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. Count 6. Fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, Starbucks. The defendant is guilty of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. Count 7. Fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, Walmart. The defendant is guilty of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. Count 8. Fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, Seacoast Bank. The defendant is guilty of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. Count 9. Fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, Home Depot. The defendant is guilty of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. Count 10. Fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. Ann Therese Aesthetic Medicine. The defendant is guilty of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. So say we all, dated June 26, 2025, four-person.
Does either side wish to have the jury polled?
Please.
All right.
Mr. Crosley, is this your verdict and the verdict of the jury as a whole?
Yes.
Mr. St. Clair, is this your verdict and the verdict of the jury as a whole?
Yes.
Ms. Najjar, is this your verdict and the verdict of the jury as a whole?
Yes.
Ms. Hunt, is this your verdict and the verdict of the jury as a whole?
Yes.
Ms. Karen, is this your verdict and the verdict of the jury as a whole?
Yes.
Ms. Ortego, is this your verdict and the verdict of the jury as a whole?
Yes.
Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. With that, ladies and gentlemen, again, we thank you for your service. You may get whatever belongings you have here. Make sure that you get them out of the jury room, and the bailiff will escort you out. Thank you.
All right.
Wow, guys. Jury came back. Remember, we only had 6 jurors on there. Okay, wait 1 second.
Guilty of second-degree murder in count 1, tampering with physical evidence in count 2, count 3 through 10, for fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. They found you guilty on each of those counts. So I will adjudicate you on all counts that the jury found you guilty of on the verdict form, including second-degree murder and tampering with evidence and the fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, again, in counts 3 through 10. What says the state regarding sentencing?
Judge, if the court would like to go ahead and sentence Mr. Davis today, he is not entitled to a pre-sentence investigation report.
Okay.
Mr. Davis has been repeatedly convicted of multiple felonies. As such, he would not be entitled to a pre-sentence investigation report.
All
I
right.
do believe that we have members of the family and friends that are present that would like to address court.
For victim impact?
Victim impact. Otherwise, if defense counsel is seeking an additional date, we understand that as well. So.
Okay. All right. And from the defense, then, is there any reason why the court cannot pronounce sentence today?
Judge, I would ask if we could set it out. I was inquiring about if you want your family members to be present, which we don't know at this time, but that's the reason I would request to put it out a month or so.
But do you agree that he's not entitled to a PSI, pre-sentence investigation
His prior
report?
convictions. I mean, he was brought from a prison here from another state.
Okay. I don't know what his prior record is, but other than that, do you anticipate there was no one, was there anybody here today or throughout the trial on his behalf that is here today to be here? Or?
Okay. I guess we could proceed.
All right. The state want to proceed then? Do you want to start with victim impact, or would you rather make a recommendation at this point, or how would you like to proceed?
Judge, if the state may have a brief moment to speak with the victim's family members.
Okay.
With regards to, so that way we can narrow down who would like to present, who would
That's
like
fine.
to argue to the court.
I'll give you a few minutes.
Thank you, Your Honor.
All
Appreciate
right.
that.
I am going to fast forward us through this portion so we can get right to the part where they are doing the statements. Thank goodness for TiVo time. Let me get that together for us.
Was it big?
Okay, here we go. I think this is a good place for us to start. They're going to start with the victim impact statements, it appears. Okay.
Copy the same score sheet as well.
All right.
With that, Judge, if I may, the state would like to present victim impact at this point in time.
You may.
And follow that up with a brief argument.
All right.
At this time, Judge, the state would call Miss Verna Bernstein.
Just raise your right hand. Do you swear or affirm testimony you give will be the truth, the whole truth, nothing but the truth?
I do.
You can take the stand.
Go up here.
You may proceed whenever you're ready.
Thank you, Your Honor. Good afternoon, ma'am.
Good afternoon.
Would you please introduce yourself to the court by telling him your name?
My name is Verna Bernstein.
And did you know a gentleman by the name of Barry Schmalbach?
I did.
And how did you know him?
He was my nephew, my step-nephew. My sister is Vivian Schmalbach, and my niece is Emily Schmalbach-Scaletta.
And is there anything that you'd like to bring to the court's attention that you believe is pertinent with regards to sentencing in this particular case?
Yeah. Barry was a big, beautiful light in my family's eyes and their life. He was there with Emily when she was growing up. They became really good friends. And even later in life, he came back to the family. And he's just always been a very kind and generous person, almost to a fault. But Emily was getting so much closer to him again, and she had just lost her dad. She lost her grandmother, who she was close to, and now this. And it's heartbreaking to see someone you love go through this much loss. And it's just unbelievable. You never think it's going to happen in your family. But in this case, it did. And, to not be able to grieve for him properly. I just think it's so unfair. He did not deserve to go this way. He just gotten healthy. He was trying to live his life, and he was just taken like that. And he should have been on this earth. He would have meant so much more to more people. He was kind. He was respectful. He took responsibility for, his mistakes in his life. And, it's a tough loss for our family and for his friends. He had a lot of very close friends. So I'm here speaking for my sister and my niece.
Thank you, ma'am.
And he's also going to miss the birth of his first niece. Maybe not his first niece, but. Thank you.
Judge of State would like to call Ms. Sherry Steyer.
Do you swear or affirm testimony you give will be the truth, the whole truth, nothing but the truth?
I do.
You can take the stand. You can do that.
Hi.
Good afternoon, ma'am.
Hi.
Would you please introduce yourself to the court by telling him your name?
My name is Sherry Steyer.
And Ms. Steyer, do you know a gentleman by the name of Barry Schmalbach?
Yes,
And how did you know him?
he was my baby brother.
And is there anything specifically that you'd like the court to take into consideration as it relates to sentencing this particular case? As it relates to your brother?
We weren't very close at the end, but I've always loved him. I always knew he was a good person. I'm sad that we're never going to be able to reunite on this earth. I look forward to seeing him. We are good. We are at peace together. I know this in my heart. I am sad that Barry was just starting to get his business going when this happened. And I miss him. I've always missed him, but I really miss him now. And I hope this is okay to say, but he does come to me in my dreams. That's how I know that he's okay and he's at peace. Okay.
Thank you, ma'am.
Thank you. Thank you.
And lastly, Judge, the state would like to call Ms. Rosalie Falico.
If you'll just raise your right hand, do you swear affirm testimony you give will be the truth, whole truth, nothing but the truth? You can take the stand.
Thank you. Good afternoon, ma'am.
Hi, good afternoon.
Would you please introduce yourself to the court by telling him your name?
My name is Rosalie Falico. I am Barry Schmalbach's friend for 40 years.
You're one of the same Rosalie Falico that testified in this case.
Yes, please.
Anything
Sorry.
that you'd like the court to consider as it relates to sentencing this matter?
Yes, please.
Please.
Okay, so Barry Schmalbach was not just a friend. He was a family to all of us, and we all showed up for him. He may have looked like he lived in Florida alone, but he had a whole tribe that was always by his side. Barry was a ride or die. He stayed with his people. He was loyal. He was admirable. He was a person who brought everybody together. He had friendships all over the world that lasted lifetimes. If you met him for 5 minutes, you loved him because he was genuine and very, very, very truthful and very true. He was the best person you'd ever meet. Barry's sister can't travel because she's having her first baby. And Emily wanted you to know that she just got her brother back. And Chris took that away from her. He took away the niece that he would have loved to have seen and bounced and held on to. She misses him dearly and she loves him. She's happy the justice was served, but she's a baby. She's only 30. So she missed out what could have been her older years to really enjoy her family as an adult, which got taken away from her. And she's an only child. So she truly doesn't have any other siblings now. That was her family. She's blessed in many ways, but her brother is gone. And that's something that we cannot ever replace. And Barry left a mark on everybody. I think he left a mark here as well this week. People that knew him for a year or two, people that knew him for lifetimes. Margaret was like a daughter to him. And I heard many stories of the deep love he had for Margaret and Leon. Leon's is his family. Leon is his brother. There's the love that is in this room for him can't be matched. And we would show up 110 times if we had to for him. So I just wanted you to know that he was an amazing person. That's all.
Thank you, ma'am. I have nothing further to present at this time, just mere argument.
All right. Anything from the defense this time?
Argument, Judge.
Okay.
We proceed. We'd ask the court if you do see a score sheet, you'll notice most of the priors are all property crimes from Georgia and South Carolina. And there's no crimes of violence in past history. The score sheet guidelines recommend a lowest permissible of 286.05. We'd be requesting that sentence from the court. Thank you.
All right. State.
Judge, this court over the past 3 or 4 days has received information and it's gone through 40 some odd witnesses. It's gotten 57 plus pieces of evidence before it. It's heard all the arguments. I'm not going to go ahead and be repetitive. I'm going to be brief and tell this court that the only sentence that Mr. Davis deserves in this particular case is nothing short of life. Respectfully requesting Mr. Davis to be sentenced to life. We're respectfully requesting Mr. Davis to be sentenced to the 15 years for the tampering of evidence in this particular case. We're also asking that this court sentence Mr. Davis to 5 years on each count of the fraudulent use of personal identification information by a deceased individual. And we're asking that all of those particular counts run consecutively. And that's for the cost of prosecution, Judge. We're respectfully requesting the court to order and reserve.
Okay. Any other of the financial, any statutorily mandated fines, fees, or costs, and are there any minimum mandatories in any of the counts?
There are not, Judge.
We're just seeking a PD fee and cost total $400. Any objection to that? $400.
$400
The
defense counsel fee?
Defendant said he had no objection
Okay.
to that fee, Your Honor.
Mr. Davis, is there anything you would like to say to the court prior to the court pronouncing sentencing? Okay. And is it true you have no objection to the defense counsel's request for $400 in defense counsel fees? That is true or not true? It is true. Okay. All right. So let me take care of the financials. Are there any statutorily mandated ones? Okay. So under count one, which is second degree murder, I previously stated that the jury had found you guilty. I adjudicate you guilty on that count. You will be required to pay the $400 in defense counsel fees. I'll order in reserve on cost of prosecution. There is a minimum statutory amount of $100 that I will order that, and I'll order in reserve on anything above that. There is $413 in court costs and no other application fees or anything. Or is there? Well, there would be an application fee.
There's one.
$50 public defender application fee. $2 for law enforcement fee for Cape Coral. So that's $415 in court costs then. You will be ordered to have no contact with the victim's family. And
Excuse me, Your Honor. If I may interject, I apologize. I may have misspoken as related to the tampering charge. It's a third-degree felony. It's punishable by up to 5 years in the Department of Corrections. So say would be asking that be 5 years and obviously consecutive as well. So
each of those you wanted consent.
yes, Judge. Thank you.
All right. All right, then. So on the tampering with physical evidence and each count of the fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individuals. That's counts 3 through 10. Each of those is a third-degree felony. And again, you've been adjudicated guilty under those counts, and I will sentence you to 5 years in the Florida Department of Corrections on each count, consecutive with each other and consecutive to the sentence that I will pronounce in count one. That means they run one after the other. They don't run at the same time. Then in each of those counts, counts 3 through 10, I will order restitution reserve on any amount in there. And again, in count one, I will order restitution reserve on any amount if that comes about. As for count one, second degree murder, I've reviewed the court file. I have taken judicial notice of the court file. I have presided over the trial and listened to the testimony and evidence presented. I have reviewed your criminal punishment code score sheet. It does appear you have numerous felony convictions. Looks like mostly out of South Carolina and Georgia. lowest permissible sentence on this criminal punishment code score sheet is 286.05 months. The maximum sentence under this offense would be life in the Florida Department of Corrections, a life sentence. It is the considered judgment of this court that as to count 1, second-degree murder, which I had previously adjudicated you guilty, you will be sentenced to life in the Florida Department of Corrections. That sentence will be imposed, and all the other counts, the sentences and the other counts, will run consecutive to that, including count 2, which is tampering with physical evidence, a third-degree felony, and on that one, you're adjudicated guilty and sentenced to 5 years in the Florida Department of Corrections. That sentence will run consecutive to count 1, and then counts 3 through 10. Each of those will run consecutive to each other, meaning one after the other. But as to count 1, you will receive the sentence of life in the Florida Department of Corrections. And what credit does he have?
365 days.
You get credit on each of the counts for that. Again, there'll be no contact with the victim's family and any other terms or conditions.
There you are. Thank you.
All right. Sir, that'll be your sentence. You have 30 days to file an appeal. An appeal would have to be filed with the Lee County Clerk's office here in this building. You've been appointed an attorney for this trial. If you can't afford an attorney for the appeal, the court will appoint one for you. But just remember, you've got 30 days from today to file an appeal. That will be your sentence, and you'll just get fingerprinted and remanded. Go ahead.
But I think you also need to order a DNA sample as well. Judge.
I'm sorry, what?
A DNA sample?
Oh, I'm sorry. Yes, you also be required to submit a DNA sample for the FDLA DNA database. Thank you.
Thank you.
And that'll be each of the counts. So here's the verdict form.
Family hugging the prosecution. Well, we done seen him get fingerprinted. And Christopher has been found guilty on everything and is running consecutively. Like, he don't have a chance. Like, he has life. Then he got found guilty on count 2, which is 5 years. Then he got found guilty on counts 3 through 10 for the fraudulent activities. Those are 5 years apiece. So that's 7 of those. So we talking about a total of 35 years just on counts 3 to 10. Then you got the life. Then you have count number 2, which has another 5 years. So on counts 2 through 10, we got a total of 40 years. And then we have the second degree, which is going to be a life sentence, right? I guess they put this in place just in case he come back. Like if he passed away in jail and come back, he got to serve life again. I don't know. You guys tell me. I don't know. But I'm glad that Barry's family and friends have some type of closure. It would have been nice to know where Barry is. I don't know if Christopher will ever find it in his heart to let this family know where their loved one is in order for them to be able to respectfully bury him and give him the proper funeral and services that they need. Oh gosh, it just breaks my heart for them. Very emotional. I'm so glad that this happened, and the jury didn't take long. I'm surprised, but I guess not surprised. It was only a jury of 6 that had to decide this in this case versus the 12 people being back there. And it's not like a capital murder like the trial that we're watching currently, where we are in a penalty phase with Ronnie Walker. Of course, if you're watching this video, definitely check us out in the Ronnie Walker's penalty phases. If you missed any of the video footage from this trial, the trial started on Monday. All the footage is up under there. I made a nice little playlist and everything for everybody to review. In order for you to catch up on a weekend or whatever the case may be, is there for you to review. I guess that will conclude everything that we have today for taking it to trial. We took this to trial real quick, and we definitely, we're able to complete this. And of course, so they got us looking at the seal now, so I can kind of tell. So once again, you were in the right place, right? There's no fluff, no filter, just facts. So you can be the judge. Thanks, guys.